I just wanted to let you know I was here. I just wanted to let you know I was
You're
here.
here on Stephanie Dansford? Are you a witness?
I'm
Oh. Come on, Dana. Come on. Stand by, man. Have a seat.
Your Honor, may I stand at the podium briefly to discuss it? Thank you.
Right. Motion may begin whenever you're ready.
I may begin how, Judge?
Whenever you're ready.
Thank you, Your Honor. The court, having reviewed the motion, we think it's pretty clear that what happened in this case is that Ms. Loyd had been given notification that there was a GoFundMe page, and that when she was given notification, she immediately, I'd like to invoke the rule of sequestration, please.
That applies to the motion to dismiss, that would only be a hearing, so when we get, if we get to the motion, or get to the hearing, then I'm happy to do it then. But for the legal argument, I'm going to deny your request.
Yes, Your Honor. Let me find the motion as I'm looking here. Please. And that on the 19th, is my understanding, she was given notification that the GoFundMe page was still up, and she immediately removed the information from the internet, the GoFundMe page. It's my understanding that Samantha Eastman, the supervisor, had noted it on the necessary affidavit, and also on the other documentation that supported the warrant in this case, and that Margot Sloan was the officer in charge of the community control of my client, DanaLoyd, and that the court will note that on that date and time, when it was set aside, the community control officer testified under oath at deposition on October 18th that she became aware of the technical violation on December 20th, 2017. Ms. Sloan testified that she sent a letter to the then presiding judge, Judge Lemonitis. Judge Lemonitis was the judge who tried the case, or who was the trial judge in the case, and entered the orders as attached to and made part of this record. On December 21st, 2017, she outlined the alleged violation, but concluded that the officer believes that the offender has not violated this supervision. So let me go back. On December 21st, 2017, Ms. Sloan, on behalf of probation and parole, indicated to Judge Robin Lemonitis that the officer believed that the offender had not violated supervision. Ms. Sloan testified under oath in her deposition that Judge Lemonitis instructed her to process a violation, notwithstanding the position of community control officer, via a phone call from Judge Lemonitis to her judicial assistant, at that time, Janie Robinson. Ms. Sloan complied with Judge Lemonitis' directive on December 29, 2017, in contravention of her own analysis that Ms. Loyd had not violated her supervision. The violation of probation was therefore generated directly from the trial judge, not the officer of probation, which is assigned the duty in accordance with Florida Statute 948-061C. What we're saying again is that Judge Lemonitis overruled the probation officer, Margot Sloan, and told her to go ahead and violate Ms. DanaLoyd. And under the Florida statutes, it says under 948.061C, if a probationer or offender on community control commits a technical violation, the probation officer shall determine whether the probationer or offender on community control is eligible for the alternative sanctioning program under Section 9, subsection 9. If the probation officer determines that the probationer or offender on community control is eligible, the probation officer may proceed with the alternative sanction program in lieu of filing an affidavit of probation with the court. In the present case, the probation officer determined that no violation existed at all, yet she was overruled by the trial judge in an ex parte directive. We contend that if you look at the 4th DCA case of appeals, as cited Mitchell versus State, you get the state as well as the court and head coach. It is very clear in that case that 642 Southern 2nd 1108, a 1994 case, that they had commented that we condemn in the strongest terms the practice, if it is a practice, of trial judges meeting with probation or community control officers on an ex parte basis to discuss incipient violation charges and possible dispositions. The role of a sentencing judge is to impose a sentence, not to supervise the executive branch authorities in their execution of it. We contend that the Honorable Judge Robin Lemonitis exceeded her jurisdictional bounds when she directed the supervisor, either and/or Samantha Eastman and/or Margaret Sloan in particular, to go ahead and violate DanaLoyd. Although she is not sitting now before as the honor in this court, and you are, the fact that she violated her jurisdictional bounds violates the entirety of the violation. It is absolutely inappropriate that she took that move and made that order in accordance with the affidavits and the documentation as supported in the deposition, in particular of Samantha Eastman, where it talks about, I emailed you on Friday of last week, 5 days ago. This is Exhibit 1 about the GoFundMe page that was still up, and it mentions my daughter, gives links to other sites that are posting false information about them. Then she goes on to say, Ms. Eastman, thank you for your below email. Your email below supposes that we know all of the posting internet sites and accounts she has access to. We do not. The court orders are absent any detailed locations for us to access, and quite frankly, the court issued a gag order, so I cannot talk to her about you or the other named victim in the case without her directly violating her probation. We are working with the information you have provided in the below listed email. Thank you. This is Eastman to the alleged victim on December 20th, 2017. Then you'll see where it goes on to say, we're investigating the below issues. This is, again, Exhibit 3 in the deposition that's attached to the deposition. We are investigating the below issues you brought to us. It takes a little time to do our investigative part. Please be assured that we'll handle all allegations. Will be forwarded to the court for review. They had some difficulty understanding the orders that they received on 12/7/17. She was not instructed on the orders when she initially reported on 12/5 due to the circumstances noted above. The orders were obtained on 12/7. It goes on, based upon the information above and absent a signed probation order signifying her acknowledgement of violation is not willful at this time. It is only willful after she is instructed, has signed the orders and fails to comply with the order in that 24-hour period. This is Samantha Eastman on December 15, 2017. Then there's a letter of December 21st, 2017 to Judge Lemonitis, and that's attached as Exhibit 5 in the deposition, again, of which I've given to the court clerk to have it filed on behalf of Samantha Eastman. There is a full 2-page document, and at the very last page, at this time the officer respectfully recommends that the court issue a notice of appeal for hearing to address the violations issued. Listed, the officer respectfully recommends the offender continue on supervision, modify as reflected. But again, it talks about the fact that she had not violated. The offender had stated that the GoFundMe account was set up by a third party, and she had asked that third party in front of her attorney as a witness to deactivate the account and shut it down. The offender stated this conversation with the third party occurred on 12/12/17. On 12/20, the GoFundMe page was still active according to what Supervisor Eastman had said. And again, previously, as we indicated in the documentation, there was absolutely none. No violation whatsoever, was not willful at that time as of 12/15/17. You'll see that there's many other letters where Samantha Eastman says, "Thank you for your below information. Unfortunately, I personally gone to this site multiple times and cannot locate her page." So for the reasons that we've cited to this honorable court, as noted, that the violation occurred because, again, according to the documentation and the deposition of Margot Sloan, was because she was directed, as we indicated, by the JA for Judge Lemonitis to go and violate her, even though there was not a violation indicated by probation or committee control.
Judge, we ask that you deny the motion to set aside the violation of probation. I haven't had an opportunity to look at the depositions that Mr. Ross is talking about, and I don't know about whether there's any veracity to any of the things that are alleged in the motion, but even assuming all of that's true, the Mitchell case that he cites to got reversed because the judge who had the alleged review of that violation didn't grant the motion to disqualify him or herself. In this case, we don't have that issue. Judge Lemonitis is not hearing the violation of probation, so the state would ask that you deny the motion to set aside the violation of probation. We have the violation of probation hearing as required by law because there are 2 violations alleged. Now, whether or not this court determines that those are willful or substantial because it was 13 days late that she shut this GoFundMe page down, that's a different issue. What I'm saying is that there's no mechanism by which to just set aside the violation of probation without hearing the actual evidence.
I think based on what I've heard, that the state has a uphill battle, but I don't, since I'm not the judge that ordered any of this up to this point, I think I need to hear it. I think that the deposition needs to be put in the record for me to
I filed both of them.
notice of it. You have a chance to review
I
that.
have it, but both of the witnesses are here.
Yeah, so I think that needs to be put in the record. I think we need to hear the witnesses, and should be fairly short and sweet, I would think. It's just a matter of the 13 days. It's a matter of who knew what when, and
It's not
deny your motion.
With all due respect, it's not 13 days, Judge, it's on the same day. So you'll see.
You said 13 days. I didn't. I just got that from what you said.
Those are different dates and times, but here in the
I
deposition.
understand, and I'm going to hear it in the hearing, right?
Yes, sir.
Okay, you first witness.
Judge, the state calls Margot Sloan. She's in the hall.
So we can rule sequestration.
Now you may, absolutely. If you are a witness that is going to come to the stand in this case, please stand up, if you would. Anybody? I know you're not one witness, but you can remain standing. Anybody else? You ready? Okay. Only one?
Yeah, the other one's already outside.
Oh, okay. Rule of sequestration has been invoked. When your testimony is done, don't discuss it with her or anybody else who makes me to be attorney. Swear affirm testimony about giving the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please have a seat. Yes, ma'am.
Thank you. Please state your name and spell your last name for the court record.
Margo, M-A-R-G-O, Sloan, S-L-O-A-N.
And how are you employed?
I'm a probation officer with the State of Florida Department of Corrections.
And how long have you been employed in that manner?
24 years.
Okay, and were you the supervising officer for the defendant in this case, DanaLoyd? Were you the supervising officer
At what time?
ever?
Yeah, one time I was, yes.
When?
December 2 years ago.
Okay. Did you file the affidavit in this case for the violation of community control?
Yes, I did.
Okay. She was placed on supervision originally for 2 years of community control, is that right?
Yes,
followed by 3 years of probation.
yes.
So were you her community control officer then, and then not her probation officer, or did she have more than one community control officer as well?
Yes. She had 3 community control officers.
Okay.
Well, actually, more than that. Upon sentencing, she was sentenced to the first year to be in the jail. So the first, I think, 8 months, she was actually incarcerated in a jail. And at that point, the file was being held in Titusville by a couple different officers up there. And then upon her release from the jail, she was assigned to me. After that, she was assigned to Miss Flannery, and then Mr. Montanino.
Okay.
And now she's had subsequent probation officers since then.
Because her community control ended and it started to be the probationary term.
Objection leading.
Yes.
And in this affidavit, it alleges that her violations were failing to comply with the lawful instructions given to her by her community control officer, specifically to take down a GoFundMe page account that she had previously had. Is that correct?
Yes.
Okay. Tell me how you all came to learn that there was this GoFundMe page that was allegedly up and violated her supervision.
One of the conditions says she cannot, it's worded about having the ability to have the information about the case and or the victim. So she came in and I instructed her on our orders on, I think it was December 7th, 2017.
Okay.
And after she left my office, I actually pulled up her website on my work computer. If I remember correctly, is it Brevard's Best News? I'd have to look because they were all named similar. And upon accessing that, there was a link to the GoFundMe page. So I clicked from her website to the GoFundMe. And that's the only time I've ever been to the GoFundMe website. It was asking for assistance with her legal fees on the GoFundMe, but inside the GoFundMe it had all.
Objection, Your Honor. Without the GoFundMe page, we object to hearsay.
Hearsay is admissible in the OP.
And they need
About to say that too?
to have the GoFundMe page here to demonstrate to the court instead of her interpretation of the GoFundMe page.
I think so.
We think that the best evidence rule is the GoFundMe page.
That may be true, but hearsay is admissible. It is hearsay. There's an exception. It's a violation of probation hearing, and I'll allow it.
Okay, let me back you up just a second before you get into what you saw on December 7th, 2017. Prior to you viewing the GoFundMe page, you had instructed the offender that she was to remove all information regarding the victim and the victim's father. Is that correct?
Well, at that time I called her.
I mean, after you watched it, after you saw it?
Yes.
Okay, so you met with her, you gave her the instructions, then you said you went to her webpage, and there was a link to the GoFundMe page. What was on there that, in your opinion, was of concern?
Objection, compound question.
What's your concern?
The case material, the information about the case was on there.
And how long after you spoke to her for the first time about removing it did you see this? What's the time frame?
30 minutes. She had just left the office.
So I guess the violation would be 30 minutes does not equal immediate.
But yeah, so I called her about it.
Later that same day,
Yeah,
after
the
you'd
same
seen
day.
it, and when you called her, what did you say? What was that conversation?
In regard to the website, which I think was run by GoDaddy, her initial response was she would shut the entire thing down, and she did that immediately.
Okay.
In regard to the GoFundMe, I told her she could have a website in regard to asking for attorney fees, but everything about the case and or the victims had to be removed.
And did she acknowledge that she understood what that requirement was?
She told me that a third party made the website, the GoFundMe.
Okay. And then what did you do from there?
She told me that she would have talked to the third party.
Okay, did she say who that was?
No, she did not.
What, if anything, did you do next?
Well, the following week, she went to Volusia County for an appellate hearing, and she told me that in front of her attorney, his name was Alex, she talked to that person, and she told that person to shut the site down.
Okay, and that was, you said a week later, so maybe around.
I want to say it was around the 11th or the 12th.
Okay. And then, what happened next?
Then that's when, probably a week later, Ms. Eastman got involved and said that it was still up and active, and she could see that it was actually,
Objection, Your Honor, hearsay. It can't be the sole cause of the judge's decision. I still have to object to hearsay.
but Eastman could see that the, author of the account was actually Ms. Loyd, and she then called her and said that, shut down the
Objection
sorry.
to double hearsay as to Ms. Eastman talking to, Ms. Sloan talking to Ms. Eastman, who's looking at a GoFundMe page without the GoFundMe page here, it's double hearsay.
Go ahead.
She told her to shut it down, within an hour it was shut down.
Okay, and that was approximately when? The 20th?
I think, yeah, 12/20.
Okay, your affidavit says 13 days later.
Yeah.
All right, do you, is there anything else important that you think the court needs to know regarding this violation? Your recommendation was basically that she remain on supervision. Is that correct?
Yes.
I don't have anything else.
You know, during that 13-day period that's been referenced several times, if the GoFundMe page had been modified to take those items off that you suggested come on?
I never checked it again, no, I did not.
Cross.
You received emails from the alleged victim, the father himself, is that correct?
Say again,
You received emails from the alleged victim, the father himself, who was then deemed to be the victim as opposed to the alleged child of the information that was given in the criminal case, is that right?
yes, I did.
And one of the emails that you received was on Friday, December 15, 2017 at 3:41 p.m., is that right?
I don't recall.
May I show the witness?
Any reason to disagree that that date's wrong?
No, I mean,
Go ahead.
No.
Someone is right.
Thank you. Then on or about that date, you remember that you were told by the alleged victim that the search parameter was pretty simple for this. I typed in DanaLoyd, and it's the third item. I'm surprised that neither you nor Dana, a
Can
convicted...
I object to the relevance of these emails?
Let him finish first. Let him finish what he read first.
Neither you nor Dana, a convicted felon, has actually been proactive on the search for this after as many emails as we have had. I understand being willful, however, the order was pretty clear that your team sent me 24 hours, everything should be down. It's not. I would assume in addition to being willful, an actual effort has to be put in place, clearly based on my emails that I previously sent, show a clear lack of effort to take everything down until I send an email concerning email links and screenshots of the violation. Is that correct? You received that?
Again, I don't recall.
Would it refresh your memory by looking at it?
I can't look at it.
May I approach the witness?
Well, I'm just going to object to the relevance still, because
How's it relevant?
It deals with the time factor, Judge, that they received notice on December 15th from the alleged victim that there was a GoFundMe page that was up and running. It was on that date, not the 7th, as she says, that she allegedly told my client somewhere thereafter on the 7th, but it was the 15th that she actually found it and then started to call her in. Michael, thank you. May I approach?
Yes.
It's Exhibit 1 on the deposition.
The top of the page is to Miss Eastman, it's not to me.
Okay, are you familiar with it? Ms. Eastman is your direct supervisor.
Okay.
Are you familiar with that?
Well, Well, you were asking if I received it, but the answer then would be no.
Okay, have you read that email from the alleged victim giving you notice and or knowledge about the GoFundMe page on December 15th, 2017? I'm sorry, what?
I don't recall if I got it or not back 2 years ago, I don't know. Because it wasn't sent to me.
Well, did you receive emails from the alleged victim, or did it go to Samantha?
He was emailing her directly.
So you were not getting any?
Mm-mm.
So on the 7th, that you say that you went back and you went into the GoFundMe account, you never told the defendant, my client Dana Loyd, that you went back in and found a GoFundMe account that had any information about the alleged victim, the father, did you?
Yes, I did click on the GoFundMe and I did see it myself on the 7th.
You never told the defendant on the 7th, allegedly, when you filled out the affidavit sometime later on the 29th, you never told the defendant on the 7th or shortly thereafter that there was a GoFundMe page up, did you?
The defendant being Miss Lloyd?
Yes, that's who the
Yes, I
defendant
spoke
is.
to her myself on the 7th,
When you
on the
filed,
telephone.
you
Yes, I
filed
did.
your violation report when?
Is it the 29th?
Well, I'm asking you if you know, ma'am. Please don't ask me.
Can look at it if you want me to look at it.
Sure, if it'll refresh your memory if you have it there.
It's the 29th.
Okay, so the only thing that you believe that she did is fail to remove the GoFundMe account, is that right?
Well, follow the instructions and to remove it, yes.
And you waited until the 29th of December 2017 to file the violation report, is that right?
Yes.
And that was because you didn't find out until the 15th of December through the email to Samantha Eastman that there was a GoFundMe account up, and didn't call Dana Loyd in until the 17th of December.
Compound question.
Ask and answer.
You didn't find out until December 15th, 2000.
Ask and answer.
Thank you. May I get that document back?
Did someone direct you to do this?
What?
It's not your direct supervisor about this?
The violation?
Yeah.
After the letter was sent, yeah, it came from the judicial assistant
Telling you, more or less.
to process a violation, yes.
And your recommendation, as we sit here now, is just stay on probation and come see me, like you're supposed to.
Yes.
And your supervisor sent a letter indicating, what?
Seriously?
No, nothing else.
Would you like to redirect or call to do this?
I was going to call Samantha Eastman.
Yes, that-
It's made up, it's all.
Come on up. Nice to see you again.
Excuse me.
What firm testimony about giving you nothing but yourself?
Good afternoon. Please state your name and spell your last name for the record.
Sure, it's Samantha Eastman, Eastman.
And how are you employed?
I am employed by the Florida Department of Corrections.
And as what?
I am a correctional probation senior supervisor.
All right. And how long have you worked for probation?
Almost 21 years in January.
Okay. Were you in some way involved in the case that we're hearing today, the violation of community control filed against Ms. Dana Loyd?
I was.
And tell the court how you became involved in that.
My major involvement was direct emails from the victim to me.
And the victim being Timothy, is it Michaud?
Correct.
Okay. And when did you receive an email from him?
The first email I received was on the 7th of December about a Facebook page that was still up and active.
You say 7th of December, you're talking December 2017,
Yes.
is that correct? Okay. And what was his complaint or issue about the Facebook page?
Objection. Hearsay.
The complaint was that the Facebook page was still up and not taken down within 24 hours upon release.
Okay, she had been released the day before.
On the 5th of 2007, December 5th, 2017.
Okay. Then she had a meeting with Ms. Sloan on the 7th, is that correct?
Correct.
Okay. And was advised of the conditions and that she needed to take
Objection,
those
hearsay.
down?
Correct.
Okay. And you weren't involved in that meeting?
Objection, leading.
Were you involved in that meeting?
No.
Okay. And then how did you get involved after that?
The victim emailed directly saying the Facebook page was still up.
And when was that?
Hearsay.
12/7/17.
Okay, 12/7/17. Was that the only email that you had from him, or were there some more later?
There were multiple
Okay.
emails
All
on
right.
various dates, back and forth.
Okay. And in general, what was the issue that he was having?
Well, the first issue was that the Facebook page was up, and we gave her the benefit of the doubt because she wasn't instructed until 12/7/17, when we got the official orders.
Sure.
Because there were some confidentiality issues with getting the orders to the clerk. And she was instructed, the confidentiality is actually marked confidential, not restricted, it was actually confidential. When we got the orders, Officer Sloan on 12/7/17 instructed her, victim, very frustrated that the Facebook page was still up. We confirmed that it was still up and up. I called her directly, she came in the next day on 12/8/17, took it down.
Okay, and you're talking about the defendant?
The defendant,
So
she
the
took
Facebook
it
page
down.
on 12/8 was resolved?
Correct, no violation, and we decided no violation at that point.
Okay, then what happened? Tell me about the GoFundMe page.
Sure, unbeknownst to anything of what Officer Sloan did on 12/7/17, I got an email on 12/15. I'm not sure I got it on that day to read it, but the email came in dated from the victim on that day, 12/15/17. And the email was that she still had a GoFundMe page open and active.
Okay, and then based on that information, what did you do?
It wasn't until 12:20 until I paid attention to the email. I get a lot of emails every day. And I personally went to that page and saw her GoFundMe page. I saw it, and I saw her as either an originator, author, organizer, I can't exactly remember the word, but it had a little picture of her.
Okay, and what was the problem with her GoFundMe page? How did it violate her conditions of community control?
It had victim-sensitive information on it.
Okay, like what?
The complaint, what he did, what she did, in generics, I can't remember word for word, but it had the victim's name throughout.
Okay, and she had previously been instructed that that had to come onto that page?
Correct, well, she was instructed on 12/7/17, but she was instructed by me on 12/8/17 when she came in to resolve the Facebook issue to take down any other social media so we don't have to deal with this in the future.
Okay. And then what did you do after you had noticed that on 12/20?
I directed Officer Sloan to do violation.
I don't have any other questions, Judge.
Yes, sir.
You said you saw the GoFundMe page under DanaLoyd or DanaLoyd?
It was DanaLoyd, I believe, that I can recall. It's been a couple years.
So you don't know whether or not it was www.gofundme.com Dana Delaney? You don't know that, do you?
I can't recall, the link was actually sent to us by the victim.
And you don't know whether or not it was a third party who set that up, do you?
Correct, sir.
Only that you were told by the defendant it was a third party who set it up. Isn't that right?
Can you repeat? I was told?
You were told by the defendant that it was a third party who set up the GoFundMe page. Isn't that right?
I don't necessarily recall that.
I see. Now, at some point, you've been 20 years as a supervisor with the Department of Corrections. Is that right?
Not 20 years, but close.
Okay, and you were working for Department of Corrections on or about the date and time that you came into contact with DanaLoyd. Is that right?
Yes, sir.
And the first time you came into contact with her was on or about the 7th or 8th of December 2017, is that right?
In direct contact, yes, sir.
But she was released from jail on 12/15/17, right?
No, sir, 12/5.
I'm sorry, I meant 12/5/17. She was released from jail, is that right?
Yes, sir.
And she reported directly to probation on 12/5/17, didn't she?
Yes, sir.
And it wasn't until 12/7/18 that you could actually put her on probation, is that right?
12/7/17, that she was instructed on the conditions that had nothing to do with it at the time she started probation.
And you had, But you believe that she would have started on 12/5, even though she didn't get placed on probation until 12/7/17, is that right?
We didn't formally instruct her until 12/7, so that's the date we went on.
And you assigned her to Officer Sloan,
Yes, sir.
and you would be her direct supervisor, is that correct?
Yes, sir.
And were you able to place her on probation on the 12/7/17?
Yes, sir.
And as you said, having placed her on probation, did you read to her the special conditions of her probation?
No, sir.
But you did read the special conditions of her probation, right?
I read them separately, yes, sir.
And you know that they're confusing and they're overly broad, is that right?
So Miss Pringle here, Miss Pringle.
She probably would know better than anybody.
Yeah.
The conditions she was violated for, no, sir. But all the other conditions, I do agree, they were a little wordy.
And on 12/7, you didn't sign the probation's orders with her, did you?
No, sir.
You believe Officer Sloan may have?
Yes, sir.
And you believe that Officer Sloan would have read each and every one of these, is that right?
Yes, sir.
And or it would have been initialed,
Yes.
but you haven't seen it to see whether or not it's initialed, is that right?
No, sir, not that I can recall.
And the one condition that you believe she violated was condition that she had to remove from the internet within 24 hours of being released any and all items pertaining to the victim and the victim's daughter, is that right?
Yes, sir.
And it was a special condition on the third amended order as to count 1 to remove this information from the internet regarding the victim, victim's father, Dean Tong, within 24 hours, is that right?
I believe it was on the original, sir.
Do you know what date was that? Well,
It was amended 3 times.
on page 15 of, did you give a deposition on or about July 2nd, 2019?
Yes, sir.
Was I there?
Yes,
Was
sir.
the state attorney there? Jason Anderson on behalf of the state?
Yes, sir.
And ma'am, on page 15, you were asked the question, if you know, line 13, if it helps refresh your memory, answer, line 15, sure. It is a standard. It is a special condition on the third amended order as to count 1 to remove all information from the internet regarding the victim, victim's father, and Dean Tong within 24 hours of release.
That's
Is that what you
correct.
said?
That is correct, sir.
So it was on the third amended order, isn't that right?
Right.
And do you know the date of the third amended order?
I can't recall, sir.
July 12th of 2017, is that correct?
I can't recall.
Now, do you know if one of the conditions of her probation is not to use the name of the victim, the father?
If you could show it to me, I could answer that question.
Well, having read all the conditions, do you know that she is not supposed to say the name of the father to anybody? Not post it, not
Yes.
write it, not talk about it, not talk to anybody whatsoever?
Yes, sir.
So, considering that, so when you go and do a search on the internet, if she could not use the name of the victim, or if she could not use the name to do a search to make sure that his name was no longer associated with her name, how could she then do it?
I'm not sure how to answer your question.
In
sir.
fact, you said that would be a good question in your deposition, isn't that right? So do
I
you
don't
know,
disagree.
do you know whether or not her name is throughout the internet, not only because of Facebook or other internet sites, but because of her work on Best News, Brevard Business News, or Brevard's Best News?
Can you repeat the question?
Sure, she uses the internet for her business, Brevard Best News, is that right?
Sure.
For a
yes.
multitude of reasons, she's on the internet. So she could run her name and come up with godzillion numbers of hits for her name alone, is that right?
Probably.
But the only way to find out if the alleged victim, the father's name is there, is for her to run that name, is that right?
I would assume so, sir.
And that would violate her conditions.
Correct. If she did it herself, it would violate.
And do you know whether or not she had a Facebook page on or about 12/5/17, when she first came in the office and reported immediately after the jail?
Not on 12/5, on 12/7.
You were asked a question on page 17. Do you know whether she had a Facebook page in or about 12/5/17? Answer line 6, yes. So is it yes or no today?
She had a Facebook page.
So you knew it on 12/5, is that right?
It would have been more than 12/7 than 12/5.
And you had brought her into your office on 12/8 of 2017, is that right?
Yes, sir.
And you didn't tell her anything about a GoFundMe page on 12/8, did you, ma'am?
I didn't know about it at that time, sir.
So Ms. Sloan never told you anything about it.
No, sir.
Now, so within 24 hours after being released to remove the things from the internet, you don't know of any individual who gave her special permission to use the name of the victim, do you?
No, sir.
So when my client was released on 12/5/17 and had 24 hours to remove the items from the internet, is that correct?
Yes, sir.
And on 12/7/2017, while my client was in Officer Sloan's office, did the victim call her, do you know?
I don't recall.
So, but you know the victim contacted you almost daily, and you cannot recall the exact date and time?
Via email, sir.
So you don't know if he emailed you on that date and time, do you?
It was on or about 12/7/17.
You didn't list a log of when he would call or email, did you, ma'am?
I don't believe he spoke on the phone. I believe it was always through email.
And if he and you talked, you could not recall the time or date, is that right?
Again, it was on or about 12/7/17.
So did you have any specific knowledge through, let's say, from December 7th of 2017, whether he called while my client was there with Officer Sloan in the office?
If he called, not that I
Yes.
can recall.
Do you have any knowledge whether the victim was upset that my client had been released from jail?
I can't recall.
Now, isn't it true that on or about 12/7/2017, that it was up to you or my client or Ms. Sloan that suggested that the entire paper, Brevard Best News, be removed from the internet? Do you know whose suggestion that was?
I don't recall.
It was my client, the defendant, who said she would remove all of Brevard Best News to make sure she didn't go to jail because she was scared that there could be anything on it. Isn't that right?
I don't recall that conversation, sir.
And she, on the 8th, removed the Brevard Best News. Isn't that right?
I can't recall that conversation.
I asked you the question on page 20, line 3, on or about December 7th, 2000. Sure.
Fresh recollection.
Just this part?
Yeah, you can read from there down.
And I believe I wrote that could be possible.
But all you know is you weren't there when the victim would call and or email to Ms. Sloan. Is that correct?
I was not there when the victim called Officer Sloan. I wouldn't have known when she got emails, unless he copied me.
And what was the reason that you had to return on the 8th, and since you had been there on the 7th?
It was due to the Facebook page. I wanted to make sure she understood she needed to get that down.
And she immediately got it down that day, is that right?
Yes, sir, absolutely.
And do you know whether it's simplistic or hard to remove a Facebook page because it reestablishes itself?
I am not that savvy with that, so I would not be the best person to ask that question.
Do you know
I
she,
have no clue.
do you know she used her brother-in-law to fully remove the Facebook page?
The projection assumes facts not evidence and relevant.
It's a question. You can answer if you don't. I doubt you know.
I don't recall, sir.
So do you know that as of December 8th, you would agree that both Brevard's Best News and Facebook had been deleted completely from the internet, is that right?
To the best of my knowledge, yes, it was removed.
And on or about 12/8/17, you had no reason to violate her, did you?
Correct.
And then you called my client on the morning of 12/19/2017, is that right?
I don't recall that.
Would it help to refresh your memory to look
Yes.
at your deposition, page 22?
And I wrote it could be possible.
Okay, so it was somewhere, if it wasn't definitely 12/19, then it was somewhere between 12/12 and 12/20, but you thought possibly 12/19, is that right?
Correct.
And why did you call her?
I cannot recall.
Because the victim again indicated in an email that she had a GoFundMe account active and live. Isn't that why you called her?
I cannot recall that.
Would it help to refresh your memory, look
Sure.
at the deposition, page 22, line 21.
I don't recall.
Okay, does that refresh your memory?
Not really.
So, even though you said this, the victim again indicated in email that she still had a GoFundMe account active and live, you don't recall saying that in your deposition?
No, I do recall saying that. I don't recall speaking to her on 12/19.
But when
It
you
could be
called,
possible.
whether it was the 20th or the 19th or the 18th, whatever day it was, that's when you received some information that there was a GoFundMe account that the victim had told you about. Is that right?
Correct, on or about 12/20.
And you called my client to tell her that there was a GoFundMe page that was still out there online. Is that right?
I just don't recall that I called her on 12/19, 12/20. I don't recall.
Whatever the date was, you called her after you heard from the alleged victim. Is that right?
It could be possible.
And you heard on December 15th, you don't know when you read it, but in an email that he complained about a GoFundMe account. Is that right?
Correct. Yes, sir.
Under Dana Delaney, isn't that right?
Correct.
Not DanaLoyd.
Again, I do not recall.
Okay, so somewhere after the 15th, up until the 20th, you had received information from the alleged victim and you called her to tell her that. Is that right?
The 19th or the 20th. I cannot recall the exact date.
Whatever date it is, the 19th or the 20th, you called her and you told her that there was a page that was up called a GoFundMe page. Is that- Thank you. So then, after calling her and telling her about the GoFundMe page, it was taken down within an hour after that. Isn't that right?
Yes, sir. Exactly 1 hour.
So she called you within an hour.
Always good to end on a high point.
I'm done.
I said that. Any additional witnesses? No witnesses from the defense, I presume? You'd like to explain motion?
Yes, Your Honor, to have it dismissed.
The two officers that have testified here today in my courtroom have done so numerous times, and I find them to be very reasonable in their recommendations. And if they say there was no violation, I have no choice but to agree with them, because the facts don't point to a violation, as they have said in their words and in their actions. So I'm going to dismiss, and I do not find anything that was done to be substantial or willful. Have a good day.
Thank you, Judge. Have a great day.
While we were doing that,